Hi, thanks, Kim. Thanks, everyone for joining us today. Just our quick disclaimer, this presentation is for educational purposes only. It is not legal advice and does not create an attorney-client relationship. We'll have some information at the end on contacting us if you have specific questions. And also, so you can get on with your day, I'll try to move through this information rather quickly. So one of the new hot topics is the California Workplace Violence Prevention Policy. So all California employers, and I'm sorry, it says all employers, but this is specific to California, must have a compliant workplace violence prevention policy as of July 1st of 2024. Now, this was a pretty extensive bill that was passed, and the Labor Code sets out a lot of requirements that must be in the policy, including approved training for all employees. So just like with sexual harassment training, presumably lots of agencies that offer workplace training are going to pop up with this workplace violence prevention training that is going to comply with the Labor Code, but the Labor Code is pretty extensive on this, and we have not received any clarifying guidance or FAQs from DIR yet. So this is one to be watching until July 1st as it changes and as the requirements become more clear. So one big change in Illinois is from the ESLA, which is paid sick leave, to the PFLAW, which is the law, the paid leave for all workers. What's changed with PFLAW is that now leave can be used for any reason. It is not restricted to the requirements under ESLA, which is only for sick and safe leave. With the PFLAW, you must carry over unused leave to a 40-hour accrual cap, and the employees do accrue 1 hour for every 40 hours worked. Now, there is a way to front load this. If you front load, you still have to allow carryover up to that accrual cap. And so it's a little different. It's a little more going to be a little more employee friendly. And like I said, the leave can be used for any reason, not just sick and safe leave. So this is something, if you're in Illinois, you're going to want to make sure that you are aware of. Nevada and Maine also have paid leave that can be used for any reason, not just illness or safe leave. So we can see this as a trend that's happening across the US, and that leave will be used. We can see more leave laws where the leave can be used for any reason. So that's going to be something you want to keep an eye on in your jurisdiction. Some new consequences under the EEOC with a new case that just came out. So what happened was an employer denied a deaf job applicant's accommodation request and terminated his candidacy because they said verbal communication and hearing were job requirements for the position in a remote setting. And they did not explore other options. They just said you have to be able to speak and hear in order to meet the functions of this position. And they did not do the interactive process. They did not go into accommodations such as assistive technology. So what ended up happening to this employer, and what let this be a cautionary tale as far as cutting employees off without really giving the interactive process one through. So they ended up with a $150,000 payout, but addition to the payout, the EEOC made the employer update its reasonable accommodation policy. Now that should not be necessary if you have an Ask HR, myHRcounsel handbook. And it required all training for all HR and management on discrimination law. Now it also, the EEOC also required the company to issue an annual executive video message on the company's commitment to ensuring that people who are deaf and hard of hearing are provided reasonable accommodations. So they had to put that video message together every year. The company's human resources personnel were required to complete an online training focused on integrating deaf employees into the workplace. So that includes the expense of training for all the company's human resources personnel. One of the HR team members must be designated to complete additional training on assistive technologies that deaf or hard of hearing employees or applicants may use to communicate in the workplace. They must also make specific job postings on a job board targeting deaf applicants with a specific notice that affirms that the employer is committed to the full inclusion of all qualified individuals, including deaf applicants. The employer must contract with an American Sign Language vendor when that is needed to provide accommodation. They must post notices in the workplace. They must create a tracking system for accommodation requests for deaf and hard of hearing individuals. So as you can see, this is costing the employer a lot more than just the settlement amount. And none of this would have happened had they engaged in the interactive process and worked with the candidate to explore all possible reasonable accommodations, including an ASL interpreter and assistive technologies in the workplace. So starting at the this case that just came out under the EEOC is just showing you that that you're going to save money on the front end by looking for and implementing those reasonable accommodations. Joint employment, this is something that everyone is talking about. So the final rule implementation has been moved to 2/26/24, but there are still legal challenges to the final rule in the Circuit Court of Appeals. So this is not a one and done right now. This is not the actual final rule. A lot could happen between now and 2/26/24 in the courts with the challenges to the joint employment rule. Just a little, if you're wondering what this means, how is this going to change for you? So the rule under the 2020 Trump administration ruled that when two entities will be considered joint employers of particular employees when the workers are required to demonstrate that a company exercises substantial, direct, and immediate control over the essential terms and conditions of another company's employees. The new rule that's proposed right now, and like I said, it is not final, is that if a company possesses the authority to control whether directly, indirectly, or both, or to exercise the power to control whether directly, indirectly, or both, and whether or not they're actually exercising that power, one or more of the employee's essential terms of conditions of employment. So under the final rule, it's going to be immaterial whether the company actually exercises control over the terms and conditions of the employee's employment, as long as the company has the authority to control one essential term and condition of a worker's employment, then that the joint employer test is going to be satisfied. But like I said, keep an eye on this. A lot can happen between now and the final rule date. This is just to prepare you what might happen, but it is not final. The OSHA final rule for record keeping and recording requirements has changed. Currently, establishments with 250 or more employees in any industry must submit information from their Form 300A and illness and injury logs electronically to OSHA. And only certain types of establishments are with 20 to 249 employees are required to submit such data. Now, OSHA's final rule that's going to go into effect on January 1st expands on these electronic record-keeping obligations by requiring establishments with 100 or more employees that are listed in Appendix B will have to submit their 300 log corresponding 301 incident reports and 300-day annual summary data, and workplaces listed in Appendix A with 20 to 249 employees will have to submit the 300-day annual summary data electronically. Now, the automatic electronic submission of 300 logs is going to lead to more OSHA investigations because now OSHA is going to be able to identify more high incident employers. So if you have a question about this, I would advise opening a ticket, or if you are not a client, signing up for our services so that you can open a ticket in our Ask system and be able to get more clarification on this. Changes to minimum wage. Some states have changed the minimum wage altogether. Some states have changed wages for tipped employees. Some states have stopped differentiating by the size of employer or whether or not they offer health insurance. It is not enough to Google minimum wage Alaska. You could get outdated or non-specific data. myHR will post the minimum wage increases on the blog, and they're going to go into effect on 1/1/24. But things can still change legislatively between now and then, so we will have these in the beginning of 2024, and just stay tuned as to whether there might be a change in the new minimum wage in your state. Marijuana plus laws. Ohioans are the latest to pass legalized recreational marijuana. Ohio does not require employees to continue to employ someone who fails a drug test, even though it is legal. Colorado has legalized psychedelic substances such as mushrooms, peyote, and DMT. Colorado does not require employers to accommodate the use of these psychedelic substances, so you don't have to let anyone work on mushrooms. Don't panic yet on that. And Washington State no longer permits employers to discriminate based on an employee's legal off-duty marijuana use. So positive cannabis and metabolites in a drug test are no longer a reason to refuse to hire or terminate an employee's employment. New rules in Connecticut on artificial intelligence. There are new rules on data privacy. You can see there are a lot of actions taken to study AI and to implement policies regulating AI in the workplace. Now, although this is just Connecticut, this is a harbinger of what other state legislatures will have on their agendas in the next legislative session, for sure. So this is something that it will expand from state to state. The Connecticut law requires the Department of Administrative Services to inventory AI in state agencies. Watch that spread to private employers. Right now it is just state agencies, but there is no reason that private employers cannot suddenly be covered by that too. So employers using AI in Connecticut must comply. Employers in other states should start preparing for new rules on AI, such as required audits of automatic decision-making and other hardware and software. So you should get ready for those required audits. The California Consumer Protection Agency has just established draft framework for the use of AI in the workplace. So like I said, this is definitely one to watch and to keep up with in your jurisdiction, because this is definitely something that is about to be a big wave across the nation. So thank you for joining us today. Again, you can open a ticket in the Ask HR system if you are a client and have more questions. If you are not a client, you can always reach us at info@myHRcounsel.com or go to www.myHRcounsel.com to learn more about our packages that could help you with legal advice on all the issues I discussed today and so many more. So remember that compliance is not optional. Thank you for joining us today, and please, like I said, reach out in the Ask system or email us with any further questions about the webinar. So I hope you all enjoy the rest of your day.